I want to talk about evidence and my position. I'll get to this slide in a minute. That evidence is not rules, right? You go to a law school class, you learn the rules of evidence. Well, we're going to talk about the rules of evidence as tools for lawyers, all right? Because I'm a believer. Let me ask you this question. How many of you appear in front of judges who truly understand the rules of evidence? Okay, I see no hands, all right? And how about prosecutors who understand the rules of evidence? Okay, some of you fainted at that question. So, okay, you're going to know the rules of evidence and really control the courtroom. So, you know, I had this whole PowerPoint planned, and then I read the description that's on the agenda, and I realized I covered none of it. So I changed it this morning a little bit. But the first thing was, how do you get the good stuff in and keep the bad stuff out? So if you're not already engaged this way, I am a firm believer in litigating motions in limine. I know that's really hard in a high volume practice, but you have to try and think about litigating motions in limine, right? If you can give a judge a written pretrial motion, you won't get a seat of the pants response. I mean, let's make it as simple as that, all right? And obviously, it's a lot better to move in limine to preclude mention of your client's 5 prior rapes than to object in front of the jury. We know that. All right, what else happens? Sometimes you'll be forcing the other side to disclose what it has to combat certain evidence, and then you're going to know. Or you'll just be moving in limine to tease out whether they have something they haven't told you about. Why else do you want a motion in limine? To know what you may say in your opening and to handcuff the other side and prevent it from saying things it ought not. Another strategic reason. You're going to take the judge's temperature. If you litigate a motion in limine, especially when I show you the way I want you to do it, which is the next slide, you're going to get a real sense of where your judge is going on a lot of this case. And once you have the judge's temperature, it may also be time to go back and have a heart-to-heart talk with your client about rethinking that plea offer, right? But it's really important to know early how the judge is going to treat you and this case. So my final word about motions in limine actually goes back to what we heard this morning. And I must say this as a public shout out to Keith. I've been teaching trial ad for a long time. I've gone to 8 gazillion lectures. One of the best I ever heard, okay? Maybe the best. So this whole thing about stories. Well, judges need stories too. And the way to litigate a motion in limine properly is to write it up as a story. My client accused of blank has an actual defense because he was home with his mother. Not just his mother, but Father Smith from the local parish. But Father Smith is unavailable, and Mom has a 7-year-old prior conviction for X. Now you go into why that's inadmissible under Rule 609. But if you start out with, we move to exclude the 7-year-old conviction of mother, you're nowhere. So make it a rich storytelling. Judges need stories too. All right, so when we first talked about this, and I have to compliment the folks who put this together, there have been months and months and months of planning for today. That's a shocking notion, but really a ton of work, okay? And a lot of talks. I said, yeah, I'll do an evidence thing. What should we focus on? So we came up with 3. One is impeachment. The second one, which we'll get to, is hearsay, which is always a mind-boggler. And then the third big one, character and other acts evidence. So let me start off with impeachment. And of course, that's what it feels like. So I'm so glad you mentioned Abraham Lincoln this morning. I mentioned this to you. I want to tell you an Abe Lincoln story because I want to use it to sort of contextualize the discussion about impeachment, law and strategy. So what happened is Lincoln, and there's a whole book written just about this trial of Lincoln's. was asked by a family friend to represent the son of the family. Two guys were charged with killing a man in a fight in the middle of the field. Co-defendant's case went to trial first, and Lincoln learned what happened, that the eyewitness said, I was standing at the edge of the field and I could see this thing. Why? There was a full moon overhead. Okay, well, that's a bit of a concern. Full moon can generate an awful lot of light. But Lincoln was a scientist, so he checked the scientific volume of the Farmer's Almanac. Not exactly good science, but the best at the time. And the moon was most of the way down. It wasn't dark, but it wasn't directly overhead. And so the question, and we'll come back to what Lincoln did, is what are you going to do with that? Is that good impeachment? How do you use it? When do you use it? Do you impeach intrinsically? Do you impeach extrinsically? All sorts of questions could bubble up from that. So we'll do the big why first, which is, why do we impeach? And we have to remember, doctrinally, you know, we always think of impeaching as destroying a witness's credibility. And that's one reason to impeach. But let's think more strategically. We may impeach as well to support our version, right? The thing you left out, or your prior statement tells us, right, different from what you said today, that the victim did have a baseball bat. So don't think narrowly about impeachment, that it's just tearing them down. Impeachment can be building us up. Okay, why else impeach? First of all, juries expect it, right? This is the drama. They pay attention. It shows your control. Here are some other ones. You do a good impeachment, you get a jury instruction, right? The significance of a prior inconsistent statement, the significance of a crimen falsi conviction. With extrinsic impeachment, the impeachment by character, bad witness character. Now, let me stop there. How many of you think jurors understand jury instructions? Okay. I got a half a hand, okay? But the answer, because I bet you would say this, is they understand jury instructions when we embrace them and incorporate them into our closing, maybe even our opening, and we make them comprehensible. So the value of the instruction is less that the judge is going to say it than that because the judge is going to say it, you're going to use it. And you're going to use it effectively so that when the judge says it, it gives you the good housekeeping seal of approval. It reinforces what you said. So let's master impeachment. This is my dichotomy. I think it's correct. That if you conceptualize all the different ways there are to impeach, they really fit in only two categories. One type of impeachment of a witness is character impeachment. And that says you have a bad character in terms of honesty, dishonesty, therefore let's not believe you today. All right? The other kind, and nobody else uses this term, this is mine, is what I call case-specific impeachment. You may be honest in general. I don't know. I don't care. But today, in this case, you're either lying or mistaken. And that's impeachment by bias. That's impeachment by inconsistent statement. That's impeachment by, you didn't have your glasses on. And I think I see some of you out there now, right? Impeachment by inconsistent facts. So you're going to categorize your impeachment in terms of evidence law. Because before you do it, you have to understand why you're doing it, and the evidence law gives you the context that then lets you argue it properly. The other reason you want to do this is because sometimes you're going to have witnesses, and when the other side impeaches your witness, you have to make sure they don't overuse that impeachment, that they're limited to what the law of evidence says it may properly be used for. Now, impeachment in law, part 2. what's the relationship between impeachment and the hearsay rules? Well, if I impeach you with an inconsistent statement that has no hearsay admissibility, all it means to the jury is don't believe what the witness said today. If I impeach you with an excited utterance, with a statement made for purposes of medical diagnosis and treatment, a statement of party opponent, whatever it is, you get 2 bangs for the buck. Because then it's not only don't believe what the witness said today, but jury, you're allowed to believe what the witness said in that prior utterance or writing. So again, that's just, I need to know that. So if the hearsay is admissible under 801, 803, or 807, then you get to say, hey, you can take that to the bank. It's as if I had a live witness say that under oath. So this is, again, like categories. I'm sorry I used a poorly colored chart. The other thing is that some impeachment may only be done intrinsically, on cross-examination. Some may be done only extrinsically. Some may be done both. So you need to know which is which. All right. Here is one of the maybe 2 most underutilized rules of evidence for trial lawyers, and that's Rule 806. If the prosecution brings in hearsay from a declarant who never testifies, well, there's nobody for me to cross-examine, is there? But 806 says, go to town. You have the absolute right to impeach the absent hearsay speaker, the same as if we had a live witness. So if John comes in and is allowed to tell us Tom's excited utterance, you can bring out Tom's 609 conviction or anything else you have. So don't get cowed when it comes in as third-party hearsay. Still do your investigation. Still do your aggressive litigation. By the way, I will make, this is the 80th iteration of this, I'll make this available, and can we email it to everybody so we have an email list? So I have some citations later. You'll all get this as a PDF. So I'm so happy to see some of you writing, although if that's what you're ordering for dinner, get me some also. Okay, let's get back to work. All right, so then, once you really know the law, now the rest is courtroom style. And by the way, the next time you watch that movie, one of the great movies, pay heed. This is one of the worst cross-examinations ever done. Won't you really tell us what happened, right? Okay, not good. We'll learn about better cross-examination tomorrow. But let's go back to Abe Lincoln. So Lincoln had this quandary. What do I do? What do I do? Right? Do I set the witness up? Do I use leading questions? Do I impeach extrinsically after he's off the stand? And does the impeachment still work? Because remember, saying the moon is there, they're just saying the moon is at, like, there. It's kind of lateral. So Lincoln actually was the master. Don't do this. When we get our cross-examination lecture, it's going to be all about only ask leading questions and only one fact per question, and I totally subscribe to that. But Lincoln was a maestro. So he broke the rules, and he did it like this, and he set the person up, and it was beautiful, because what happened? He then handed the person the Farmer's Almanac, and this is exactly what the jury did according to contemporary accounts. They burst into laughter, and so it was a devastating impeachment. And to me, the lessons are, if you have incontrovertible physical evidence, assuming the Farmer's Almanac qualifies as such, it's okay. And then the reminder, he could have delayed the impeachment, but we would have lost all the drama there, right? Impeaching 2 days later would have done nothing. One other thing, we always have to think with our evidence hats on, how the hell was the Farmer's Almanac admissible, right? Is that a learned treatise? No, but in 1857, it was judicially noticed as accurate. So you go where you can. All right, how may I impeach me? This is Elizabeth Barrett Browning. Let me count the ways. All right? Reminder, anyone may impeach anyone, including your own witnesses, which happens too often. 608A, really interesting impeachment, again, underutilized. And actually, going back to our investigation lecture previously, that's the one investigation we didn't talk about. Finding people who can say that the complaining witness has a reputation for dishonesty. How many of you have ever called a 608A witness? Okay, like 3. Okay, so this is my almost second most underutilized. Actually, it is the second most underutilized rule. So the rules of evidence say, forget character, like violent, nonviolent, right? We have very strict rules limiting that. But every single witness is subject to attack by calling somebody else to, you know, I hate to pick on former President Clinton, okay? Brilliant guy, totally ruined death penalty law, but that's okay. But you know what? If Bill Clinton testified to an auto accident, we could call 1 million people and say, what's his reputation? As a liar, right? Only to 250 million people, okay? 608B. Has anyone here ever used a 608B impeachment? 1. Okay, well, in the front row, you guys don't count, okay? So what is 608B? And this again goes back to that thing about character. I don't want to offend any of you, especially my associate dean, because this is not true about you, because he has never done one single dishonest act in his life. Now, but the rest of you all have. And some of you are getting nervous as I say that. But there are dishonest acts, and then there are dishonest acts. And 608B, which not all states have, but Delaware has, the federal rules have, say, sometimes a person has committed such a gigantic dishonest act, they say, my God, if you did that, you would lie about anything. So the dishonest act becomes a proxy for a witness's dishonest character. I just gave this lecture recently to another group, and I said, you know what happens every year? You read about the local volunteer fire or ambulance, and what happens? Mrs. Simmons, the secretary for 20 years, arrested for what? Embezzling $800,000. Okay, that's a core dishonest act, right? Well, if your witness has that, you're allowed to say to her, aren't you the same lady, doesn't matter if she was prosecuted, who stole $800,000 from the ambulance corps? Go to town. Of course, 609, convictions, bias, we've talked about inconsistent statements. Contrary facts, of course, better witnesses. If you have a better credentialed witness, you're going to impeach that way. Please, this next one is really important. And prosecutors do it more to the defense, right? Well, the few times you put a defendant on, what's the prosecutor's question? Are you saying that Police Officer Smith lied? And of course the defendant is, but that's secondary, right? That's an improper question. So you have to fight to exclude that. I haven't checked Delaware law. There's good national case law about that. The jury decides who's telling the truth. My opinion or my witness's opinion that somebody else is a liar is irrelevant. But they put the defendant in an awful position there. So you want to move in limine if you're calling a client, say if you're going to impeach, can't ask that, can't argue that. And that's stuff you need to know. Inconsistent statements, very quickly. We know written, oral, sworn, unsworn, email, text messages. Remember that the rule of inconsistent statements, it's an interesting rule. Obviously, I have a sick, pathetic life that I find the rules of evidence interesting. Okay, I also read manuals. Okay, and you know, it never defines inconsistent statement. It's all about procedure. It's all about how do you do this, right? So reminder, you don't have to show it to the witness. You have to show it to opposing counsel. Too much on this slide, but basically this is that's why I'm going to print this and give it to you about the alternative, which you only do 1 in 100 times, of not impeaching the witness while she or he is on the stand, right? It almost never comes up, but it's an option. You just need to know the process. Last thing about this, inconsistent doesn't mean 180 degrees. It means inconsistent. And if it's significant enough to you, it's inconsistent. If it's something worth arguing, it's inconsistent. And of course, how can we respond if our witness is impeached? It depends on the type. If they impeach with bad character, we may impeach with, rehabilitate with good character. We can always rebuild or rehabilitate one of our witnesses who's been impeached with facts supporting. All right, so I'll breathe for 1 second and say, okay, that was impeachment. Hearsay. How many of you, I have to tell this story, do not repeat it. So I taught a webinar for judges nationally and gave some of these hypos that you're about to get. The correct response rate was 50%, which happens to be pure chance, which does not speak well. Okay, no exaggeration there. Although when I do it to military judges, I have to say this, I do a lot of training for the military, much higher success rate. Very interesting stuff. Okay, but more than you needed to hear today. So what is this, right? That's the hearsay obligatory joke, right? It's a rumor, right? And so when you're attacking hearsay, you're going to try and push it into the rumor category. All right, so here's a hypothetical. I want you to help me now. So this husband and wife, each was married previously, and each has children from marriage number one. So they each have wills now. And it says, if I die first, it goes to you, wife. But if you die first, all my stuff goes to my kids, and vice versa. So who dies first is incredibly important to the kids. Okay, so what happens? This you should never do if you have one of these wills. Don't go on a small plane together. Okay? So what happens, they go on the small plane, and the plane crashes. And the rescue people get to the scene, and there are the bodies. And a deputy walks up, and the bodies are lying there on the ground. And as he leans over, he heard the husband say, "I'm alive." He then reached down simultaneously and felt, and there was thereafter no pulse on either. And the question is, forget if it's an excited utterance, or I'm not asking that. Before we get to, is it admissible hearsay? The question to you is, are the words, "I'm alive," hearsay? If your answer is yes, raise your hand. If your answer is no, raise your hand. All right, so somebody from the no camp. Sir, you said no. Why not? No, I'm not talking about exceptions yet. We're not there. Does it meet the definition of hearsay? Because it's not for the truth of the matter asserted, although it coincidentally is. Are you saying, "Oh man, I better go back to law school"? Look at you, you're sweating. Okay? Because suppose instead he'd said, "I'm dead." Right? Okay? Or this was my, oh, sorry, that was mine. Willie Mays, and this is true actually, the greatest baseball, and it shows how old I am, right? But it does, so the first reminder is, it's not hearsay unless we're going to argue to the jury not just that it was said, but it was said, and what was said was true. Okay, that's just the bizarre, they coincide in that example, but you have to get down, is it for the truth? All right, so what's the background of the hearsay rule? It's about reliability. The theory is, this is when we glaze over in law school class because the professor's talking theory for a minute, narration, perception, memory, narration, and sincerity. And the theory is that when we don't have a live witness to cross, we can't assess those. All right, now, I'm actually going to skip this slide. This is way too theoretical, and go right to some tests. Okay, ready? Is it hearsay? Woof, woof, woof. The 3 barks mean cocaine, by the way. All right, is it hearsay? Help me out here. Oh, this is very good. Yes, no. You know, we have some wonderful guests from China, and they're saying, what's wrong with these American lawyers? All right. Why is it not hearsay? Because it's not a person. So that's rule one, okay? Whatever it is, it's under relevance, reliability, 403, but dogs do not provide hearsay. So make your objections appropriately, but hearsay does not lie here. How about this one? Is any of these hearsay? Because they're acts. Sometimes words, when uttered, also have a deed or an act. By the way, who was your evidence professor?
Professor Son.
Shit. But here at Widener, and I'll take any credit I can. That's true, and I never taught this in that class, but thank you, William. You ruined my day. Okay, so this stuff is not hearsay because some words are also deeds. Okay. This is a really difficult case. So I'm going to take a minute and talk about it. This is a murder case out of Maryland. Eric babysat 2 children. One dies. And of course, the concern is Eric's charged with murder because the injuries that caused the death could have occurred while the child was in Eric's care and custody. Jasmine's the other child. This is Jasmine's mother's testimony at trial. A day or two after Kaylin died, Jasmine, my daughter, said to me, "Mom, is Eric going to get me?" By the way, a footnote not even discussed in the case is Jasmine's 18 months old, and we can have all sorts of discussions about reliability and capacity. Are the words, "Is Eric going to get me?" hearsay? No. Who said no? I'm not calling on you again. All right, but why not?
That question is not an assertion.
Oh, now wait a minute. Okay, because I love you, William. I know this question does not apply to you, but when did you stop beating your wife? Sometimes there are assertions inside of questions. So 95% of the time, William's right. So that's part of an answer. What's the relevance of this statement? What's the rest of the sentence that Jasmine was asking in the prosecutor's eyes? Say it louder. Right. Isn't that really the thrust of this question? Is Eric going to get me the same way he got Kaylin? Because otherwise the question has no relevance. Now I have to tell you, this is on the outer, and let me add another outer fringes of the law of hearsay. The Maryland Intermediate Appellate Court wrote an absolutely brilliant opinion explaining why this was not hearsay because it's an implied assertion, and implied assertions are not covered. The Maryland Supreme Court wrote an absolutely brilliant opinion that it is hearsay because the only value to the prosecutor is the implied assertion, da-da-da-da-da-da. So just know that implied assertions are like their own weird area of the law, but this has to be careful. I mean, there are a million other issues here. There's relevance, there's personal knowledge, there's all sorts of stuff here, but a real tough one. Okay, I'm going to skip that one. So, this is pick on Bill Clinton Day, but I love using this one. I also use Bill Clinton when I teach judges about Rule 608B, because I start out asking, I explain there's some dishonest acts and there's some really dishonest acts, and then I say to the judges, okay, how many of you think cheating on your spouse is a really dishonest act that shows you'd lie about anything? And you get all these nervous looks, right? Okay, enough about judges, right? So what about this one, though, about Bill Clinton at his impeachment trial? When somebody comes in at the impeachment trial of Bill Clinton and says, I heard the president say those words, to which there were only 250 million witnesses, is it hearsay? This is so easy. that I know none of you just wants to show off. Let me ask you something. This goes back to the ritual. Things are hearsay when we look backwards. In other words, we look at the closing argument and say, what are we doing with this? Are we using it to prove he did not have sex with Monica Lewinsky? This is an easy one. No, we're using it to show he lied. Right, liar, right. So stuff like this, not hearsay, because this one, unlike the other one, the William issue of maybe it's a question, this is a statement. It looks like hearsay, but it's like the I'm alive. We're using it to show he said it, not that he said it and it's true. Is this hearsay? Imagine this is your alibi proof. No, that's an exception to the hearsay rule, but first we have to decide, is it hearsay or not? Who said no? Because. Well, I don't know, because we may be using it to show what time he left the restaurant, right? This is my alibi, sir.
It's just like a dog, it's a machine dog.
That's right. This is a machine talking. How about that one, friends, right? So the next time you go to the gas pump and you pump your own gas and I never take the receipts because I'm trying to save trees, but those of you who are evil take the little receipts, right? And you have this piece of paper and you look at it, whatever, and then you want to show, look, I was at the Sunoco station at 8 o'clock. Okay, not hearsay. There's authentication and other issues, but not hearsay. So hearsay test, this is Epstein's test. How many people have to be telling the truth? If we only want to say, did you really hear the president say that? That's one person telling the truth. Do you believe this witness or not? But if we want, come on, there we go. If we want to say, did you hear it? That's truth number one. And was that person saying a truth? That's number two. That's my test that with 95% accuracy will say, yes, it is, or no, it is not hearsay. And so this goes back to our very first slides with the I'm alive. If it's not for the truth, you ignore the hearsay rules entirely, but that doesn't mean the fight is over. There's something called spillover, okay? And this is going to link to something I'm going to show you in a slide or two. We get hit with this all the time in criminal court on what's called police course of conduct testimony. Why did you arrest Mr. Epstein? Oh, because 10 people in the neighborhood told me he did it. Objection. Only for the, not for the truth, judge, only to explain why the police arrested Mr. Epstein, right? But what has the jury heard? 10 people said Jules did it. Well, that's the spillover. And another way of thinking about spillover is Rule 403. Okay? So we're not going to buy the truth of the police course of conduct thing, and that's where we are. I want to add something for you as Delaware practitioners, and help me out if I say this wrong, okay? Delaware has actually been pretty good about shutting this type of testimony down, and not just shutting it down, but recognizing it raises a Crawford issue. Everybody got that? Because the police officer says, I interviewed Sam, and Sam told me. Well, then I'm using testimonial hearsay in my police course of conduct. So you have police course of conduct is not for the truth of the matter asserted, but it's got tons of 403 problems and even relevance problems, and now even Crawford. And again, because you're going to get these extra slides, this is just a recent federal case, 2014, which said the same thing. So courts are getting that this backdoor of hearsay is also a backdoor confrontation issue. Okay, real quick with Crawford, because we know, when I lecture on the academic circuit and the judges, I explained that Crawford was the evidence professor's Full Employment Act of 2004, okay? Because even I wrote a Crawford article, like you had, right? Everybody has his or her Crawford article. So what's hot in Crawford, I'm going to do this real briefly because we have other stuff to talk about. you know, until 2011, the United States Supreme Court made the confrontation issue fairly easy. If there was an ongoing emergency, you know, somebody's calling 911, domestic violence case, help, my husband's beating the you-know-what out of me, cry for help, not testimonial. The police show up at the domestic violence scene and separate the parties and say, what happened? Testimonial. Nice, easy divide. And I have tremendous respect for Justice Sotomayor, but she mucked it up terribly in 2011 in a case called Michigan versus Bryant, because it got all messy. And in a nutshell, in Bryant, a guy gets shot at location A and runs across town to location B, and the cops show up 20, 25 minutes later. The guy is lying on the ground. And the police say, what happened? And who did it? He said, Bryant did it. Hence Bryant getting prosecuted. Of course, the guy dies, so declarant's not there. And for the first time, the court said, well, it's a lot more complicated than is in the emergency, after the emergency. And they changed it in part to what they call an objective declarant test. And they said, and I always do this because it makes you watch, I feel like it's a religious ceremony, but place yourself in the position of the declarant. I'm lying on the ground with blood pumping out of me, and they're asking me, who did it? And if I am thinking, aha, what I say will one day be used in court, then it's testimonial. And if I'm not thinking that, it's not. So it really made it a much more complicated, and it is also, for great reading, one of the most vitriolic Justice Scalia dissents ever written. Because he's furious, right? Because this is his baby, and anyway. So that's problem number one. Forfeiture, much more important, especially since we're looking at a domestic violence case in our hypothetical. So the forfeiture by wrongdoing is if I am the defendant and I deliberately keep a witness from coming to court because I don't want her testimony, then her testimonial statements become admissible. Because I forfeited my right. But it's not merely that I killed her or I beat her up or whatever. It's I killed her, I beat her up to prevent her testimony. So there's a specific intent, if you will, a mens rea to the forfeiture. And way, you know, the court has gone nuts, is Crawford and forensics. And the landscape there we could do an hour on. So I'm just going to say it's very messy, but your Delaware Supreme Court has been much more protective of defendants' rights than some other courts nationally. So for example, not only do they say, as they must, that lab reports are testimonial, but that surrogate testimony by a supervisor who did not literally oversee the test is not admissible. So Delaware's better than some other states there. All right, one last thing on hearsay. So Bryant did it. This is the hearsay. And assume now we're past the testimonial, non-testimonial, and okay, it meets a hearsay exception. It's a dying declaration and an excited utterance. Got 2 grounds to admit it. Is there another way to challenge those words? Well, the cop said, who shot you? So we've got responsiveness there. Okay. What if I told you the guy was shot in his back? Ooh! Well, okay. Probably the most underutilized attack on hearsay is assessing it for personal knowledge. Now, personal knowledge, doctrinally, it's clear, may be shown circumstantially. The guy shot close range, front entry wound. You're not going to get that. Guy shot here, guy shot here. You've got an argument, all right? I'm just going to show you this one and go on. I didn't check for a Delaware case. I was able to find one Pennsylvania case. that talk about sort of what's the threshold for personal knowledge. But from now on, imagine the case where I'm inside and somebody runs in and says, Colette just shot the president. Okay, even if I hear the gunshot, right, first, do I know that that the person who ran in was in a position to see Colette do it? So we need some more circumstances. Otherwise, we've got to start objecting on maybe the declarant didn't have personal knowledge. Okay. Last but not least, in other words, topic number 3, the topic of character and bad acts. And please note that I took out prior and put in other. There is no requirement that the act precede the one on trial. It may be concurrent or subsequent to. So it's really the other acts rule, not the prior acts rule. All right, so first I want to talk character. So the rules are pretty good if you are representing a criminal defendant, that your client's character may be a shield rather, and not a sword, right? The prosecutor can't call 10 witnesses to say your client is violent or your client is dishonest or whatever. And that's this character stuff, because we all know character when we use words like that. But the other thing about the structure of Rule 404 is that sometimes other acts only connote character. Your client's charged with selling drugs. Well, the police want to say, and we arrested him 3 years earlier for selling drugs. Well, when my students will remember, I called that the did it once, did it again rule. And did it once, did it again is propensity, and propensity is character. So you always have to be assessing whenever the prosecution wants to bring in another act. Is the only message really, my guy's a bad guy, my woman is a bad woman. That's the character message that you have to resist. Okay, so the basic rules, forget no character in civil cases. You can't put on that the doctor's always reckless or the doctor's always careful. That doesn't work. Criminal case, it's defendant's good character, victim's bad character. The weird rule about self-defense, which I still don't understand, that if there is any evidence that you put on to say that the victim was the initial aggressor, then the victim's good character comes in. So that to me seems an over-response, but it's allowed. And of course, that's separate from that 608, 609 witness character. Witness character is always allowed. So witness character is, do we believe you? 404 character is what did or didn't happen on the day of, right? Okay. So what's prohibited? Okay, there it is again. A crime, wrong, or other act not admissible to prove a person's character to show action in conformity therewith. Okay, we know that. But then we have this wonderful list of alternate usages, right? First rule, the list is not exclusive, okay? You can make up more, it's usually the prosecutor. Pennsylvania, where my work usually is, we have all sorts of novel exceptions that somebody made up, right? A guy said, I reacted nervously when the police tried to arrest me. That's why I shot. They're allowed to bring in 5 other crimes to show he's not nervous. He does this all the time. So it's the not nervous rule. Okay, but theoretically, that's actually allowed under the rule because it's not character. It's something other than character. Okay, so the list is not exclusive. Delaware has some pretty good case law that says we have this rigorous 4-step process. Step 1, it must be for a proper purpose. Number 2, it must be relevant in general to this case. I'm not sure how that differs because if it doesn't have a proper purpose, it's not relevant. But they said 2, so we're going to argue 2. Number 3, and this is so important, the fact that it meets the standards isn't the end. Hit 403, right? And so I want to actually stop, and I should have put a slide in here, and I want to say this for a minute. You know, prosecutors and many judges treat this as a binary thing. Let it in or keep it out. And they're so loath to keep it out that they let the whole thing in. Well, it doesn't have to be the whole thing. So here's an example. We used to, when I started practicing right after Abe Lincoln retired, okay, the law was really good. Okay, and in Pennsylvania, we had these great cases. So charge is robbery on New Year's Eve. 2 weeks later, I'm caught robbing another gas station with the same gun. So they want to use my possession of the gun at gas station robbery 2 to prove identity at number 1. Our court said no. The jury doesn't have to hear it was during a robbery. That's too much. Just, he happened to be at a gas station that day with that gun, right? But that's the kind of stuff you should be arguing, right? Because that's the 403 stuff, and it's worth doing. Now, the last one, I'm going to take a contrarian position to, and here's why. Limiting instructions, right? As a young lawyer, of course I want a limiting instruction. Ladies and gentlemen of the jury, you just heard about Mr. Epstein's client 9 other rapes. That does not mean he is a bad person. Right? Now, that's a really useful instruction. Not, right? So I know your law says this, you know, and I know our first instinct is to say, boy, we want every instruction there is, right? I suspect or suggest that maybe you don't always want a 404B instruction because the jury's going to do with it whatever they want anyway, right? What you really have to do, give me 1 second and then jump in, is make sure the prosecutor doesn't over-argue it. If it's admitted for identity, don't let the prosecutor argue it for a bunch of other things. But that's a personal opinion, just something for you to think about. Sir, even going back to our 8-second rule of this morning, it doesn't work on this evidence, and when you say, by the way, forget it, right? Okay, so that's just a cautionary there, all right? And this is another just really good quote from your Supreme Court, that the 403 balance should be done in an exacting manner, all right? And again, I'm just going to send you this slide, but look at what they say in number 5. Consider the availability of less prejudicial proof. So maybe that's my thing about the gas station and the gun, all right? Use each of these points. It's, you know, who said this morning? Keith, was it you who said how great it is to read jury instructions? Like, my God, they have to prove all that? Well, if that's what they have to prove, make them. And remind your judge of number 5 if it works to your advantage. And actually, the list goes on. So this Norwood case, you know, has a lot of stuff to make it useful. Okay, so which are other acts? When are acts admissible and when are they character? This is what I use to teach my students. And this is going back to like case theory and stuff. So what I want you to do when you have a case is draw a box on a piece of paper, right? And inside the box is the time, place, and act. Usually you have one act, but you could have an expanded box. As soon as the prosecutor wants to tell your jury or fact finder any act outside of the box, it's character until heavily proved otherwise. And that's just like an organizational approach to this thing to help you to think about it. Now, sometimes acts are inside the box time-wise. So I'm arrested for murder, or I'm committing a murder, I'm arrested at the scene. In my pocket is my collection of child porn. Okay, well, that's concurrent, but it's so different, you'd separate that out anyway. All right? And what is character? And we've been through all this. So that's our approach. And that's an approach supported by the rules of evidence. Let's talk about guns, all right? So, you know, I had to look this up yesterday because I realized I didn't have stuff in here about this. Isn't it always a problem, you know, our client's charged with crime A, but at the time of arrest or when they search his house or whatever, then they find a gun. And then all of a sudden, the prosecution's trying to bring that in. So I found a couple of interesting cases, and again, you'll get these cites. If it's clearly a gun of a different caliber, it's inadmissible. And none of this, well, it shows he has familiarity with or access to guns, right? That's too much of a stretch. This case, Walker, right? This one, at least, it was like the same type. So this seemed to be okay. He's familiar with, in particular, semi-automatic. So that seems to be the Delaware approach. If there are better cases, I'm sorry, that's what I could come up with. And so they talked about that was enough to establish the nexus, right? Semi-handgun and semi-automatic handgun. Just some reminders nowadays, right? Tons of 404B evidence. We're getting slammed with this. It's all over the place. So this is a case, and I'm just going to jump to the next couple of slides because of time. And again, you'll get this cite. This is a pretty nice recent federal court case talking about those kind of photos. And the judge going through them photo by photo and saying, you know, the ones where our clients are posing like this, right? Keep it out. Some of the other ones had probative value and come in, but that stuff is just character. Okay, so let me, I think I'll finish up with this. This was my attempt, and I use this for training judges, to sort of scroll down and say, where do you cross the line from character to proper 404B? So here's the theory. Your client's charged with a robbery. The robbery happened in 2013 on Good Friday. Help me out here. Would we ever admit, well, he was not if he's not testifying, right? That he was convicted of another robbery in 2009. That's a thumbs down, right? How about the next one? It was a bank robbery in 2009. Yes, no? Got thumbs down still. You like doing the thumbs down thing, don't you? You like that motion. Yeah. Don't do that to me. Okay. Thank you. I got a thumbs up. All right. How about another gunpoint bank robbery in 2009? Still not there. So you're still on the propensity side? How about this, by the way, the Good Friday robbery in 2013 was PNC Bank. How about a 2009 gunpoint PNC Bank robbery? Are we getting warm, maybe? And then how about the last one? Another gunpoint bank robbery in 2009 on Good Friday. Can we say that's a harder one, right? And all I do with judges, because I want them to start taking a step back and saying, look how close you have to get. So that's what we do there. So, whoosh, okay, the rocket docket. So let me finish up by saying this to you. First of all, I hope this was useful. Second of all, again, we'll send out, as soon as I give it to you, the updated PowerPoint so you'll have those citations. And third is, you know, I have the luxury, right? I'm a law professor. Don't listen to this. I work like 4 hours a week, right? Oh, boy, 40. That's what I meant, 40 hours a week, right? So, you know, I get to like read this stuff and think about it. But if you take what I gave you today, it's really 2 or 3 basic things. It's know your impeachment stuff, right? Know when it is or isn't for the truth of the matter asserted. And know this inside the box, outside the box. And if you just do that and use those as like templates for assessing your cases, you're going to have the tools to really make a difference in about 80% of your cases.